Nearly 8 years ago, just 5 days into my new job as senator, I attended my very first hearing of the Judiciary Committee. It just happened to be Justice Sonia Sotomayor's confirmation hearing. So I knew that was a really big deal, and I was honored to be there, and it was a little intimidating, but I was very honored. And when it finally became my turn to speak, and I was last, of course, because I had just gotten there, what I said essentially was that I said, I think this is a pro-corporate activist Supreme Court. But I knew then what has become more abundantly clear over the past 8 years. In one 5-4 decision after another, we've seen the Roberts Court go way out of its way to answer questions not before it, to overturn precedents, to strike down laws enacted by Congress, and to do all this at great cost to consumers, to workers, small businesses, and middle-class Americans. And in no area is this bias more obvious than when it comes to forced arbitration. In Concepcion, in Italian colors, the court effectively reshaped the Federal Arbitration Act really into a permission slip for corporations to opt out of the civil justice system. From nursing home contracts and employment agreements to credit card and cell phone contracts, corporate America uses forced arbitration clauses to restrict Americans' access to justice by stripping consumers and workers of their constitutional right to have their claims heard in a public court of law. Instead, they're forced into a private justice system that is inherently biased toward corporations. Remember that corporations can write the rules in arbitration proceedings. Everything can be done in secret, without public rulings. Discovery can be limited, making it hard for consumers to get the evidence that they need to prove their case. And there's no meaningful judicial review. So there's not much a consumer or an employee can do if the arbitrator just gets it wrong. It's just not fair. So my colleagues and I have worked long and hard to reverse this wrong, and today I'm introducing my Arbitration Fairness Act, which would prohibit the use of mandatory pre-dispute arbitration agreements in consumer, employment, civil rights, and antitrust cases. This bill gives Americans a real choice. If a consumer or worker wants to take his case into arbitration, then by all means he is free to do so, provided that the corporation is also willing to do so. However, if the consumer or employee wants to go to court, then that option will once again be available to her. While I will continue to push this bill and support the legislative efforts of my colleagues here today, I refuse to forget exactly what got us here, and I'm looking forward to my next opportunity to question a Supreme Court nominee. American consumers and workers cannot afford another activist judge on the bench. They can't afford a judge who hides behind originalism to side with big business over everyday Americans. Now, I will turn this over to our first guest, former Fox News anchor Gretchen Carlson, who hails from the great state of Minnesota. Yes, thank you. Gretchen, really appreciate all you've done to put the light on this issue of forced arbitration. In July of 2016, Gretchen took on one of the most powerful men in the media, Roger Ailes, suing him for sexual harassment. The world took notice, and 2 weeks later, Ailes was forced out of Fox News. And because of your advocacy, because of your courage, because of your strength, other victims of sexual harassment have been able to come forward. So thank you. And I believe that it is in no small part because of you that other corporate cultures of gender bias have recently been unearthed. So thank you again for all of that, and thank you for joining us today. Please welcome Gretchen Carlson.
Well, I'm so pleased to be here today to join this effort. As you may know, Senator Franken and I, both from Minnesota, what you may not know is that we appeared together a couple of years ago on Celebrity Jeopardy. He beat me, but if he gets help from both sides to pass this bill, I guess I can forgive him. Little context about why I'm here today. About 30 years ago, our courts recognized that sexual harassment is a form of illegal sex discrimination, but since then, unfortunately, we've made little progress. Yes, many companies require all of us to go to sexual harassment training, and our employees are told that the workplace is safe for them. Still, over the last 9 months, I found out that sexual harassment remains pervasive in our culture. And it turns out almost every woman has a story. I plan to change that. I never expected to become the face of this issue, but once given a mission, I rarely back down. Part of my inspiration has come from my communications with so many women across this country. After hearing my story, they felt comfortable to tell me their stories, many for the first time. I've spent months encouraging them to find the same bravery that I did, to take a stand and to say enough is enough. Just in the past week, we've heard over 100 women at Sterling Jewelers, and numerous women in Silicon Valley are joining the legions of us who've been harassed, discriminated against, assaulted at work. The floodgates are opening. And still, so many other women are still being silenced by employers who force employees into the secret corporate system called arbitration. By forcing women to be silent about illegal and abusive behavior which causes them much pain, in many cases, the employer is able to leave the abusers in the workplace to harass again. The arbitration process, often argued to be quicker and cheaper for employees, instead silences millions of other survivors who may have come forward if they knew they weren't alone. Let me be very clear. This is not a partisan issue. Republicans, Democrats, and independents are all sexually harassed. The harassers come from all political parties as well. There's a lot of division in our country right now, but on this issue, we are all Americans. Americans who believe that victims of harassment should not be forced to give up the rights guaranteed by the 7th Amendment to our Constitution, which guarantees all citizens the right to a jury trial in an open public court. No one starts a job expecting to get into a dispute. I know I didn't. We start new jobs with hope, not fear and concern. So the argument that victims of harassment agree to give up their constitutional rights when they sign a contract is ridiculous. Employers are insisting that employees give up their rights in order to have that job. I bet tons of people here today, or tons of people who will watch this, have no idea if they have an arbitration clause in their employment contract. Do you know? Harassment is not only damaging to women and their families, it also hurts businesses. Men are distracted by abusing women who are not fully doing their jobs. Women harassed cannot perform at their best. Maintaining a workplace of harassment and discrimination is bad for the bottom line of any company. So let's make a pledge. Let's work together to end this. Let's take it out of the shadows of secrecy. Let's be a voice for the voiceless. Let's end the practice of employers forcing harassed women into silence through forced arbitration. Together, I believe that we can speak up, stand up, and I plan to evoke change. Thank you.
Thank you.